CPLR Article 502, conflicting venues, where because of joinder of claims or parties there is a conflict of venue, the court, upon motion, shall order as the place of trial one proper as to at least one of the parties or claims. 503, venue based on residence. Generally, the place of trial shall be 1. in the county in which one of the parties resides when it's commenced, or, if none of the parties resides in the state, in any county designated by the plaintiff. A party who is a resident of one or more counties shall be deemed a resident of each county. An executor, administrator, trustee, committee, conservator, general or testamentary guardian, or receiver, they shall be deemed a resident of the county of his appointment and the county which he resides. Executor, administrator, trustee, committee, conservator, general or testamentary guardian, or receiver. Domestic or foreign corporation shall be deemed a resident of the county where the principal office is located. A railroad or common carrier shall be deemed a resident of the county where the principal office is located and the county where the cause of action arose. Unincorporated association, a partnership, or individually owned business shall be deemed a resident of any county in which the association has its principal office and the county in which he resides. That's an unincorporated association, a partnership, or an individually owned business. The county where the association has its principal office or the county which he resides. Consumer credit transaction, the place of trial shall be the residence of the defendant. 504, place of trial. A county in such county. A city, town, village, district, school district, or district corporation, the county where such is situated, and if the school or district is in more than one county, in either county. City of New York, county within the city in which the cause of action arose, or if it arose outside of the city, the county of New York. Action against a public authority, county in which authority has its principal office, or where it has facilities involved in the action. New York Transit Authority, county within the city of New York in which the cause of action arose, or if outside the city, county of New York. 506, a special proceeding may be commenced in any county within judicial district where the proceeding is triable. A proceeding against a body or officer shall be commenced in any county within judicial district where respondent made determination complained of. 507, an action for real property, county where property is located. 508, chattel, county in which any part is situated at the time of commencement. 509, the place of trial shall be in the county designated by the plaintiff. 510, the court, upon motion, may change the place of trial where, 1, it is not the proper county. In that situation, you need a demand and a motion. 2, an impartial trial cannot be had in the proper county. Or 3, not convenient to witness, and ends of justice will be promoted by change. So, the court upon motion may change the place of the trial where 1, it's not the proper county, but in that situation you need a demand and a motion. Or 2, an impartial trial cannot be held in the proper county. Or 3, not convenient to witnesses, and the ends of justice will be promoted by the change. 511, demand for the change of venue. the demand is served with the answer or before the answer, then the plaintiff has 5 days to consent to change the venue. Or he can serve an affidavit showing that the county that the defendant picked is not proper and his is proper. If the plaintiff serves that affidavit, then the defendant can serve a motion within 15 days of when he sent the demand. So, in other words, I'm the defendant, I want to change the venue, I serve the demand on the plaintiff. He has 5 days to consent. Or send me an affidavit saying I'm wrong and he's right. If he does that, if he says he's right and I'm wrong, then I have 15 days from when I sent the demand. So if he winds up sending me that affidavit on like the 14th day, I can serve that motion in 1 day because it would be 15 days from when I served the demand. CPLR Article 6, 601 Joinder. The plaintiff in a complaint or the defendant in an answer, counterclaim, or cross-claim may join as many claims as he may have. 2 or more plaintiffs, represented by the same attorney, may join no more than 5 claims in one action. 602 Consolidation, when common questions of law or fact are pending. The court upon motion may order a joint trial or may order the actions consolidated to avoid unnecessary cost or delay. CPLR Article 10, 1001 Necessary Joinder of Parties. When a person who should be joined as a plaintiff refuses to do so, he may be made a defendant. When a person who should be joined has not been made a party, the court shall order him summoned. 1002 Permissive Joinder of Parties. Plaintiff defendant may join in one action as plaintiff defendant if common questions of law or fact arise. And the court may, to prevent a party from being embarrassed or delayed or put to an expense by the inclusion of a party, order separate trials or make other orders to prevent prejudice. 1003 Non-joinder and misjoinder of parties. Non-joinder is grounds for dismissal without prejudice, but misjoinder is not grounds for dismissal. So, non-joinder is grounds for dismissal, misjoinder is not, and non-joinder is grounds without prejudice. Parties may be added at any stage of the action: 1, by leave of court; 2, by stipulation of all parties who have appeared; 3, once without leave of the court within 20 days after service of a summons; or 4, at any time before the period for responding to the summons expires; or 5, within 20 days after service of a pleading responding to it. Parties may be dropped by the court on motion of any party or on its own initiative at any stage of the action. 1006 Interpleader. Stakeholder is a person who may be liable as a result of adverse claims, and the stakeholder commences an action of interpleader against 2 or more claimants, and the defendant stakeholder may bring in a claimant who is not a party by filing a summons and defensive interpleader. 1007, third party practice. A sues B and then B sues C. A defendant, after he serves his answer, may proceed against a person not a party to the action by filing a third party summons, and the fee must be paid, but he gets no new index number. And the defendant serving that third party complaint shall also be the third party plaintiff now. And the person served shall be the third party defendant. 1009, plaintiff may amend his complaint within 20 days after service of the defendant's answer. 1022, substitution. The time period that you have to answer or file anything shall be increased by 15 days. So substitution equals 15 days. 1023, when suing a public officer, a body, a board, a commission or public agency, it may be designated by its title. In other words, you can sue the mayor of New York. 1024, a party who is ignorant of the name or identity of a person may proceed against an unknown party. Example, Martin Doe. CPLR Article 11, 1101, motion for permission to proceed as a poor person. 1. Motion of any person is made in the court where the action is triable or the court where an appeal has been made in the appellate court. And any person making a motion shall file an affidavit setting forth the amount, sources of income, list of his property and value, state that he is unable to pay the cost and fee, nature of his action, sufficient facts so that the merit of the contentions can be ascertained, and whether any other person is interested in any recovery sought. If so, if that person is unable to pay the cost. The court may require the poor person to file with that affidavit a certificate of an attorney, and the certificate shall state that he has examined the action and believes that there is merit to the moving party's contention. And the plaintiff may seek to commence his action without payment of fee required by filing the form affidavit attesting he is unable to pay. Also, the form shall be available in the clerk's office, along with the summons and complaint or summons with notice or third-party complaint, and the case shall be given an index number, and the application will be submitted to the judge. If the court approves the application to proceed as a poor person, the plaintiff will be given a written order that all fees shall be waived. If the court denies the application to proceed as a poor person, the plaintiff will be given a written order that the case will be dismissed if the fee is not paid within 120 days. A motion is not required, though, when a party is represented by a legal aid society or a legal services or a nonprofit organization. All fees and costs shall be waived without the necessity of a motion, and the case shall be given an index number, and provided that, 1, the determination has been made that the party is unable to pay, and 2, the attorney's certification that such determination has been filed, is filed. 1102, the court may assign an attorney for a poor person. Also, where a party is permitted by order to appeal as a poor person, the clerk within 2 days after the filing of such order shall notify the court stenographer, and the stenographer within 20 days shall make and certify 2 typewritten transcripts of the trial or hearing, and shall deliver 1 copy to the poor person or his attorney, and shall deliver 1 copy and an affidavit of the facts of the date of such filing with the clerk of the court. The expense of such transcripts shall be a county charge, but in counties within the city of New York, it's a city charge. 1103, any recovery by judgment or settlement in favor of the poor person shall be paid to the clerk of the court to await distribution. CPLR Article 12, 1201, unless the court appoints a guardian ad litem, an infant shall appear by 1. The guardian of his property, 2. A parent having legal custody, or 3. Another person or agency having legal custody, or 4. An adult spouse. An infant is less than 18, so an infant is 0 to 17. An incompetent shall appear by the committee of his property, and a conservatee shall appear by the conservator of his property. 1202. The court where the action is triable may appoint a guardian ad litem at any stage in the action, either upon its own initiative or upon motion of 1. Infant if he is more than 14, or 2. A relative, friend, guardian, committee, or conservator, or 3. Any person in the action if the above have not within 10 days after completion of service. No order appointing a guardian ad litem shall be effective until written consent of the proposed guardian has been submitted to the court with an affidavit stating facts showing his ability to answer for any damages sustained by his negligence or misconduct. 1203. No judgment by default may be entered against an infant or incompetent unless his representative appeared or a guardian ad litem appointed plus 20 days since the appointment. 1205. An infant, incompetent, conservatee, person who guardian ad litem has been appointed or representative of such person shall not be liable for costs unless the court otherwise orders. 1206. The court may order that money be deposited in one or more banks for protection of the infant. 1207. To settle an action of an infant, incompetent, or conservatee, if an action was commenced, then that you have to do upon motion of the infant's guardian or guardian ad litem, or if no such guardian, then the parent having legal custody, or if no such parent, by another person having legal custody, or if the infant is married by the adult spouse residing with the infant, or of the committee of the property, or of a person judicially declared to be incompetent, or of the conservator of the property of the conservatee. So in those cases, the court may order settlement of any action commenced on behalf of the infant, and that's when an action has already commenced. But if no action has commenced, then a special proceeding may be commenced upon petition of the representative. 1208. Settlement procedure, motion or special proceeding. You need 4 things. This is to settle a case of an infant, incompetent, or conservatee. You need 4 things. 1 is you need an affidavit of the infant or incompetence representative. And that affidavit and supporting papers shall state 1, that it's going to have the representative's name and the relation to the infant or incompetent. It's going to have the name, age, and resident of the infant or the incompetent. The affidavit from the representative also has to have the circumstances giving rise to the action or the claim. It also has to have the nature and extent of damages sustained by the infant or incompetent. And if the action or claim is for damages for personal injury, the name of each physician who treated or consulted the infant or incompetent, the medical expenses, the period of disability, the amount of wages lost, the present physical condition of the infant or incompetent, and the terms and proposed distribution of the settlement, and facts surrounding any other motion or petition for settlement of the same claim, and whether reimbursements for medical or other expenses have been received, and whether anyone the infant or incompetent knows has made a claim for damages. That's the first thing it needs, that affidavit that contains all of those things. Another thing you need for settlement of an infant incompetent or in conservatee is an affidavit by the attorney. So that was the affidavit of a representative. This is the affidavit of the attorney, and that's with supporting papers stating, 1, his reasons for recommending the settlement, 2, that he has no concern with settlement and will not receive compensation, and 3, the services rendered by him. The third thing you need to settle the infant incompetent or conservatee case is medical or hospital report. And the fourth thing you need is an appearance by the infant or incompetent and his attorney. Shall attend before the court unless attendance is excused for good cause. So, 4 things that you need for settlement of an infant or incompetent: an affidavit of the representative, an affidavit of the attorney, medical reports, and an appearance. 12.11. An infant over 14 has additional rights. 12.11. Allowance for infant support. Petition to the Supreme Court, County Court, or Surrogate's Court for an application of infant's property or a portion to the infant support, maintenance, and education. CPLR Article 21. 2101. Each paper served or filed shall be durable, white, legible, and black ink, and shall be 11 by 8.5, except for summonses, subpoenas, notice of appearances, notes of issue, orders of protection or temporary orders of protection, and exhibits. That's SSNNOPE. Summonses, subpoenas, notices of appearances, notes of issue, orders of protections, temporary orders of protections, and exhibits. And beneath each signature shall be printed the name signed, and the letters in the summons shall be no less than 12-point size, all others no less than 10-point. Each paper served or filed shall begin with a caption setting forth the name of the court, the venue, the title of the action, the nature of the paper, and the index number. Summonses, complaints, or judgments. The title should include all the names of the parties. In all other papers, it is sufficient to state the name of the first named party on each side. But in summonses, complaints, or judgments, all the parties should be included. Each paper served or filed shall be endorsed with the attorney's name, address, and telephone number. And if there's no attorney, then the party. Copies rather than originals may be served or filed. Defect in form of a paper shall be disregarded by the court if the right of the party is not prejudiced. The party on whom the paper is served or shall be deemed to have waived defect unless within 15 days after receipt of the defected paper, he returns the paper to the party with a statement of particular objections. 2102. Papers required to be filed shall be filed with the clerk of the court in which the action is triable. In actions or proceedings in Supreme or County Court, papers required to be filed shall be filed with the clerk of the county in which the proceeding is brought. 2103. Who can serve papers? Papers may be served by any person not a party to the action, 18 years or older. In a pending action, you serve the party's attorney by 1. Delivering to the attorney personally, or 2. Mailing to the attorney. Service by mail shall be complete upon the mailing, and if served by mail, add 5 days to respond. If by overnight mail, you add 1 day to respond, and mailing equals first-class mail. Another way you can serve the party's attorney is by leaving with the person in charge at the attorney's office, or if nobody is in charge, leave in a conspicuous place. Also, you can leave it at the attorney's residence, but try and serve it at the office first. Or you can fax it, and the fax number on the back of the papers shall consent to service by fax. 2104. A stipulation is not binding unless 1. It must be done in court, or 2. It is in a writing subscribed by him or his attorney, or reduced to the form of an order and entered. And a stipulation of settlement shall be filed by the defendant with the county clerk. But in New York City, the stipulation of settlement is filed by the petitioner. 2106. The statement of an attorney, physician, osteopath, or dentist who is not a party has the same force and effect as an affidavit. Attorney, physician, osteopath, dentist. Civil pleadings. There must be an answer to a complaint, a third-party complaint, a counterclaim, and an interpleader complaint. An interpleader complaint, a defendant's pleading against another claimant. Third-party complaint, a defendant's pleading against another person not already a party. Reply, a plaintiff's response to a counterclaim, and the plaintiff must reply to a counterclaim. An answer may include a counterclaim against the plaintiff. An answer that includes a cross-claim is against another defendant already a party. The summons with notice. The notice has to contain 3 things: the nature, the relief, and the amount of money, except in med mal. The notice of petition only has to have 2 things: the time and place of the hearing and supporting affidavits. The notice of motion has to have 4 things: time and place of hearing, supporting papers, relief sort, and the grounds. CPLR Article 22. 2211. A motion is an application for an order, and a motion on notice is made when a notice of motion or an order to show cause is served. The notice of motion, the attorney makes the return date, and the order to show cause, the court makes the return date. 2214. Notice of motion shall specify 1. The time and the place of the hearing, 2. Supporting papers on which motion is based, 3. The relief sort, and 4. The grounds. The notice of motion and the supporting affidavits shall be served. Service at least 8 days before the hearing. and the answer at least 2 days before the hearing. Unless you're going to serve a cross motion, then you have to serve that answer and the cross motion 3 days before the hearing. If service of the motion is made to you at least 16 days before the hearing, then the answer has to be at least 7 days before the hearing, and also the cross motion has to be at least 7 days before the hearing. And then the reply will be 1 day before the hearing. So cross motions are either 3 days before the hearing or 7 days before the hearing. 2215. A party may serve upon a moving party a notice of cross motion demanding relief with or without supporting papers at least 3 or 7 days, provided that if the notice of cross motion is going to be served by mailing, then they have to add 3 days. If the notice of cross motion is going to be served overnight, they have to add 1 day. So, if the motion is served to you 8 days before the hearing, then the cross motion shall be served at least 3 days. But if you're mailing it, you have to add 3 days. So 3 plus 3, the cross motion shall be served at least 6 days before the hearing. But if you're overnighting it, you have to add 1 day. So 3 plus 1, the cross motion shall be served 4 days before the hearing. And if the motion is served to you 16 days before the hearing, the cross motion shall be served 7 days before the hearing, except if you mail it, you add 3. So the cross motion shall be served 10 days before the hearing, 7 plus 3. But if you overnight it, you add 1. So 7 plus 1, the motion shall be served 8 days before the hearing. Mailing plus 2217, an ex parte motion shall be accompanied by an affidavit stating the results of any prior motion for similar relief and specifying the new facts that were not previously shown. 2219, an order determining a motion relating to a provisional remedy shall be made within 20 days. An order determining any other motion shall be made within 60 days. And an order determining a motion shall be signed with the judge's signature or initials. 2221, a motion to re-argue or motion to renew. The motion to re-argue you do within 30 days of the order, and a motion to renew you can do any time. And they shall be made on notice to the judge who signed the order. A motion to renew, you do that within 30 days and shall be based on matters fact of law allegedly overlooked by the court in determining prior motion, and shall not include any matters of fact not offered in the prior motion, because you're just re-arguing the same motion. And 3, shall be made within 30 days after service of the order. The motion to renew can be made anytime, and that shall be based upon new facts not offered on prior motion, and shall contain reasonable justification for failure to present such facts on the prior motion. So provisional remedy is 20 days, other orders are 60 days, a referee is 30 days, and a family court order is 20 days. CPLR Article 23, 2301. A subpoena requires attendance to give testimony. A subpoena ducis tecum requires production of books, papers, and other things. 2302. A subpoena may be issued without a court order by 1. the clerk of the court, 2. a judge where there is no clerk, 3. the attorney general, 4. an attorney of record for a party to an action, an administrative proceeding, or arbitrator. 5. an arbitrator, 6. a referee, 7. A member of a board, commission, or committee. A subpoena issued by the court to compel production of an original record or a document where a certified transcript or a copy is admissible in evidence, or to compel attendance of a person confined to jail. A motion for such subpoena shall be made on at least 1 day's notice to the person having custody of the record, document, or confined person. 2302B. This was a new law effective July 3rd, 2007, amended to permit the New York City civil judge to compel by subpoena the courtroom attendance of an incarcerated person that has come before the civil court on a transfer under 325D. 2303, a subpoena and a subpoena ducis tecum shall be served in the same manner as a summons, and any person subpoenaed shall be paid or attended in advance authorized traveling expenses and 1 day's witness fee, which is $15 a day and 23 cents a mile. 2304, a motion to quash, fix conditions, or modify a subpoena shall be made promptly in the court where the subpoena is returnable. If the subpoena is not returnable in a court, then a request has to be made to withdraw or modify the subpoena, and that shall be first made to the person who issued it, and then a motion to squash, fix conditions, or modify subpoena may thereafter be made in the Supreme Court, and such motion with respect to a child support subpoena shall be made to the judge of the family court or the Supreme Court. 2305, at the end of each day's attendance, the person subpoenaed may demand his fee for the next day which he is to attend. If the fee is not paid, he shall be deemed discharged, and the cost of the reproduction and transcripts shall be borne by the person issuing the subpoena, unless the court determines otherwise in the interest of justice. 2306, where a subpoena ducis tecum is served upon a hospital or upon a department or bureau or of a municipal corporation or of the state, requiring the production of records relating to the condition or treatment of a patient, they shall be served at least 3 days before the time fixed for the production of the records. The clerk shall give a receipt for the records and notify the person subpoenaed when they are no longer needed. And 3, the record shall be delivered in a sealed envelope indicating the title of the action, the date fixed for the production, and the name and address of the attorney appearing on the subpoena. A judicial subpoena is returnable in court. A non-judicial subpoena is not returnable in court. 2308. Disobedience of a judicial subpoena. Failure to comply with a judicial subpoena issued by a judge, a clerk, or an officer of the court shall be punishable as contempt of court. If the witness is a party, the court may strike his pleadings. A subpoenaed person shall be liable to the person on whose behalf the subpoena was issued for the penalty not exceeding $150 in damages sustained for failure to comply. Also, for disobedience of a judicial subpoena, the court may also issue a warrant directing the sheriff to bring the witness into court if the person is brought to court but refuses, without reasonable cause, to be examined or to answer legal pertinent questions or produce books, papers, and other things, or to subscribe his deposition after it has been correctly reduced to a writing. The court may forthwith issue a warrant directed to the sheriff of the county where the person is, committing him to jail, which is the warrant of commitment, there to remain until he submits to do the act which he is required to do or is discharged. Such warrant of commitment shall specify the cause of the commitment, and if the witness is committed for refusing to answer a question, the question shall be on the warrant. Within 90 days of the warrant of commitment, he shall be brought before the court for review and determine whether he shall be discharged. At periodic intervals of not more than 90 days following such review, he shall be brought before the court for further review and determine whether he shall be discharged. The clerk of the court, before which such review shall be held, or the judge or justice, if no clerk, shall give reasonable notice in writing of the date, time, and place of each review to each party and their attorneys. Non-judicial subpoenas. Failure to comply with a subpoena not returnable in court. The issuer or person on whose behalf the subpoena was issued may move in Supreme Court to compel compliance. If the court finds that the subpoena was authorized, it shall order compliance and may impose a cost not exceeding $50. A subpoenaed person shall also be liable to the person on whose behalf the subpoena was issued for a penalty not exceeding $50 for damages sustained for failure to comply. Also, for failure to comply with a non-judicial subpoena, the court may issue a warrant directing the sheriff to bring the witness before the person or body requiring his appearance. If a person so subpoenaed attends or is brought before such person or body but refuses without reasonable cause to be examined or to answer legal and pertinent questions or to produce a book, paper, or other things which he was directed to produce by the subpoena, or to subscribe his deposition after it has been correctly reduced to a writing, the court, upon proof by affidavit, may issue a warrant directed to the sheriff of the county where the person is committing him to jail, there to remain until he submits to do the act which he was required to do so, or is discharged according to the law. Such a warrant of commitment shall specify particularly the cause of the commitment, and if the witness is committed for refusing to answer a question, the question shall be inserted into the warrant. And also, within 90 days of the warrant of commitment, he shall be brought before the court for review to determine whether he shall be discharged. At periodic intervals of not more than 90 days following such review, he shall be brought before the court for further review, determining whether he shall be discharged. And the clerk of the court, before which such review shall be held, or the judge or justice, if no clerk, shall give reasonable notice in writing of the date, time, and place of each review to each party and their attorneys. CPLR Quiz 4. Number 1, 2302. In general, the following may issue a subpoena without a court order: the clerk of the court, an attorney, an arbitrator, a referee, the attorney general, a judge where there is no clerk, or any member of a board, commission, or committee. Okay, so the people who can issue a subpoena without a court order are the clerk of the court, an attorney, an arbitrator, a referee, attorney general, a judge where there is no court, and any member of a board, committee, or commission. 2, 2302 and 7002. And this has to do with who can issue a subpoena to produce a prisoner. And there's a bunch of people. The first one is a judge who a petition of habeas corpus can be made. And those people are 4. You can make a petition of habeas corpus to the Supreme Court, the Appellate Division, any justice of the Supreme Court, or a county judge. So, those 4 can issue a subpoena to produce a prisoner. Also, a judge of the Court of Claims, if the matter is pending there, a judge of the surrogate's court if the matter is pending there, a judge of the family court or a support magistrate if the matter is pending before family court, and a judge of the New York City Civil Court if the matter is pending there and has been removed there from a Supreme Court. So I'm going to list the people who can issue a subpoena to produce a prisoner one more time. That would be a judge of the Supreme Court, a judge of the Appellate Division, any justice of the Supreme Court, a county judge, a judge of the Court of Claims if the matter is pending there, a judge of the surrogate court if the matter is pending there, a support magistrate or a family court judge if the matter is pending in family court, and a judge in the New York City Civil Court if the matter is pending there and has been removed there from a Supreme Court. 3, 2302. Unless the court orders otherwise, a motion for a subpoena ducis tecum for an original record or document, or to compel attendance of any person confined to a penitentiary or jail, that should be made on 1 day's notice. So to produce an original record or document, or to get somebody for their attendance that somebody's in jail, you need 1 day's notice. 4, 2303. A subpoena requiring attendance of a regular person, not a prisoner, or a subpoena ducis tecum shall be served in the same manner as a summons. Any person subpoenaed shall be paid authorized traveling expenses and a witness fee, which is $15 a day and 23 cents a mile. 5, 2306. Where a subpoena ducis tecum is served upon a hospital, so somebody wants to get hospital records, requiring the production of records relating to the condition or treatment of a patient, such subpoena shall be served at least 3 days before the time fixed for the production of the records, unless otherwise ordered by the court. So hospital records are 3 days, but any other original record or document, or to compel the attendance of a person in jail, that's 1 day. 6, 2308. If a party to an action improperly fails to comply with a lawful subpoena, that means a subpoena requiring them to appear in court, he may be held in contempt of court if he doesn't comply. If he doesn't comply, he may have his pleading stricken. He also may be liable for a penalty not to exceed $150. And he also may be liable for damages sustained by reason of not complying. Those 4 reasons are for not obeying a lawful subpoena: held in contempt, pleading stricken, liable for a penalty not to exceed $150, or be liable for damages because he didn't appear. If it's a non-judicial subpoena, he may be only liable for a penalty not exceeding $50. And for that non-judicial subpoena, you have to make a motion in Supreme Court. 7, 2308. If a person who has failed to comply with a subpoena is found in contempt of court and committed to jail and not discharged if they don't take him out of jail, he must be brought before the court by the sheriff within 90 days, and a review of the proceedings shall be held. The clerk of the court shall give reasonable notice of the date, time, and place of such review to each party or their attorneys who shall have appeared on the record in the proceeding. 9, 2309. This has to do with a form certificate or an affirmation administered within or without the U.S. by an official of the Armed Forces of the United States authorized by the RPL to take acknowledgments of deeds. And the following are true regarding this form of certificate or affirmation that's administered. 1, the rank and serial number of the officer before whom the oath or affirmation is taken and the command to which he is attached. 2, that the person taking the oath or affirmation was, at the time of taking it, a person enlisted or commissioned in or serving in with the armed forces of the United States, or a dependent of such person, or a person attached to or accompanying the armed forces of the U.S. 3. The serial number of the person who takes or whose dependent takes the oath or affirmation, if such person is enlisted or commissioned in the armed forces of the U.S. And 4. The place where such oath or affidavit is taken need not be disclosed. 10.30.01. The following are true concerning declaratory judgments. Declaratory judgments may be issued only by the Supreme Court. And if the Supreme Court denies the declaratory judgment, the court must state the grounds. And the declaratory judgment may have the effect of a final judgment and may be brought by a party who has brought a claim of personal injury or wrongful death against another party directly against the insurer of such or other party as provided in the insurance law. So declaratory judgments have to do with personal injury, wrongful death. They can only be brought in the Supreme Court. If denied, the court has to state the grounds, and they may have the effect of a final judgment. 30.11. What are pleadings? Pleadings are crap. Complaints, replies, answers, petitions. Crap. 30.16. In an action for libel or slander, the particular words complained of shall be set forth in the complaint. 14.30.20. This talks about verification. When does a pleading have to be verified? If a complaint charges a defendant with having suffered or confessed a judgment, the answer must be verified. A defense... CPLR Article 30. 30.01. A declaratory judgment. Only the Supreme Court can issue a declaratory judgment having the effect of a final judgment as to the rights of the parties. A declaratory judgment declares the rights of the parties. A party who has brought a claim for personal injury or wrongful death against a person may maintain a declaratory judgment action against the insurer of such other party. 30.11. Kinds of pleadings. There shall be a complaint and an answer. An answer may include a counterclaim against a plaintiff. An answer may include a cross-claim against a defendant already a party. A defendant's pleading against another claimant is an interpleader complaint. A defendant's pleading against any person not a party is a third-party complaint. There shall be a reply to a counterclaim and an answer to an interpleader complaint, a third-party complaint, and cross-claim that contains a demand for answer. If no demand is made in cross-claim for an answer, the cross-claim shall be deemed denied or avoided. Pleadings are crap: complaints, replies, answers, petitions. 30.12. Service of pleadings. A complaint may be served with the summons. You can also serve the summons with the notice. But the complaint may be served with the summons, and a subsequent pleading asserting new or additional claims for relief shall be served upon a party who has not appeared in the same manner as a summons. An answer or reply shall be made within 20 days after service of the pleading, except if it's not by personal service, it's 30 days. And if the complaint is not served with the summons, if you only get the summons with the notice, but no complaint, the defendant may serve a written demand for the complaint on the plaintiff within 20 days. Plaintiff shall serve the complaint within 20 days after service of the demand. And if the defendant serves the demand, it shall extend the time to appear until 20 days after service of the complaint. And if no demand is made, the complaint shall be served within 20 days after service of a notice of appearance. If service of the complaint is not made, the court, upon motion, may dismiss the action. A demand does not constitute an appearance, and if service of the summons and complaint is not personal, then service of an answer shall be made within 30 days after service is complete, and service is complete 10 days after proof of service is filed. 3012, Certificate of Merit. And a certificate of merit is in an action for medical, dental, or podiatric malpractice, and the complaint shall be accompanied by this certificate of merit by an attorney for the plaintiff, declaring that the attorney has reviewed the facts of the case and has consulted with at least one physician, dentist, or podiatrist who is licensed to practice in the state or any other state, and the attorney has concluded on the basis of such review and consultation that there is reasonable basis for the commencement of such action, or if the attorney is unable to obtain the consultation required because of limitations of time and the statute of limitations is running out or is about to expire, the certificate shall be filed within 90 days after service of the complaint. Or the attorney was unable to obtain the consultation required because the attorney has made 3 separate good faith attempts with 3 separate physicians, dentists, or podiatrists, and none of those contracted would agree to such a consultation. Where an attorney intends to rely on the doctrine of res ispa loquitur, this section shall be inapplicable. The complaint shall be accompanied by a certificate declaring that the attorney is solely relying on such doctrine and for the reason is not filing a certificate required by this section. If a request by a plaintiff for the records of the plaintiff's medical or dental treatment by the defendant has been made and such records have not been produced, the plaintiff shall not be required to serve the certificate required by this section until 90 days after such records have been produced. The provisions of this section shall not be applicable to a plaintiff who is not represented by an attorney. Pro se plaintiffs do not need a certificate of merit suing in malpractice, and certificate of merit equals 90 days. 3014, every pleading shall consist of a plain and concise statements, numbered paragraphs. Each paragraph shall contain one single allegation. 316, in an action or defense for libel or slander, the particular word shall be set forth in the complaint. In an action or defense for fraud or mistake, the wrong shall be stated in detail. In an action or defense for separation or divorce, the alleged misconduct shall be specified in the complaint. In an action or defense for a judgment, complaint shall state the extent to which any judgment recovered. In an action or defense for a law of a foreign country, the substance of the foreign law relied upon shall be stated. In an action or defense for the sale and delivery of goods, labor, and services, the plaintiff, in his verified pleading, may set forth and number the items of his claim and reasonable value. The defendant, in his verified answer, shall indicate items he disputes. In an action or defense for personal injury, the complaint shall state the plaintiff has sustained a serious injury. And in an action or defense for gross negligence, the complaint shall be verified and state whether or not the complaint is based upon gross negligence or intentional infliction of harm. So, in sale and delivery of goods, labor, and services, the pleadings have to be verified, and in gross negligence, the pleading must be verified. 3017, every complaint, counterclaim, cross-claim, interpleader complaint, and third-party complaint shall contain a demand for relief to which the pleader deems himself entitled. In an action for a declaratory judgment, the demand for relief in the complaint shall specify 1. The rights and other legal relations of which the declaration is requested, and state whether further or consequential relief is or could be claimed, and 3. The nature and extent of such relief which is claimed. In an action for personal injuries or wrongful death, the pleading shall contain a prayer for general relief, but shall not state the amount of damages to which the pleader deems himself entitled. If a personal injury or wrongful death action is brought in the CPLR Article 31, 3101 Disclosure. There shall be full disclosure of matter material necessary in the prosecution or defense. Shall not be disclosed or obtained 1. Privileged matter, 2. Attorney's work product, 3. Trial preparation. Those 3 things shall not be disclosed. Privileged matter, attorney's work product, trial preparation. 3102. Disclosure devices. 1. Depositions upon oral questions, or without the state upon written questions. 2. Interrogatories. 3. Demand for addresses. 4. Discovery and inspection of documents or property. 5. Physical and mental examinations of persons. 6. Requests for admissions. One more time real quick. Disclosure devices. 1. Depositions. Oral questions or without the state, written questions. Interrogatories. Demand for addresses. Discovery and inspection of documents of property. Physical and mental examinations of persons. Request for admission. And disclosure before an action is commenced must be done by a court order, and after the action is commenced or during trial, disclosure may be obtained only by order of the trial court on notice to the other side. So before the action is commenced, you need a court order for disclosure. And after the action is commenced or during the trial, it can be obtained only by order of the trial court on notice to the other side. 3103, protective orders. The court may at any time on its own motion or on motion of any party or of any party from discovery sort make a protective order, either denying, limiting, conditioning, or regulating the use of any disclosure device. So the protective order can be on motion of the court or motion of any party or any party from discovery sort, and the protective order can deny, limit, condition, or regulate the use of any disclosure device. 3104, upon motion of any party or witness on notice to all the parties, or upon the court's own motion without notice, the court, by one of its judges or referees, supervise all or part of any disclosure procedure. A referee shall have all the powers of the court except 1. The power to relieve himself of duties, 2. To appoint a successor, and 3. To adjudge someone guilty of contempt. So a referee can do anything that a judge can do, except he can't relieve himself, he can't appoint somebody else to do it, and he can't hold somebody in contempt. Any party or witness may make a motion to review an order of a referee. Motion shall be made within 5 days after the order is made. Review for a referee order equals 5 days. 3105. When a party is in default for failure to appear, he shall not be entitled to notice or service of any copy required under this article. 3106. Any party may take the testimony of any person by deposition upon oral or written questions. Where the person to be examined is not a party, or the person is an officer, director, or member of the employee of the party, he shall be served with a subpoena, and the subpoena shall be served at least 20 days before the examination. So if you want to examine somebody who's not a party, or if the person is an officer, director, or member of, or employee of the party, you have to subpoena them, and the subpoena has to be on at least 20 days notice before the examination. 3107. A party desiring to take the deposition of any person upon oral examination shall give each party 20 days notice stating the time and the place. But if the person to be examined is a party, you only have to give him 10 days notice. 3114. If the witness to be examined does not understand English, the examining party must, at his own expense, provide a translator. 3116. The party taking the deposition shall bear the expense. 3117. Any deposition may be used by any party for the purpose of contradicting or impeaching the testimony of the defendant. 3121. Notice of examination. After commencement of an action in which the mental, physical conditions of a party or agent, employee, or person in custody of legal control of the party is in controversy, any party may serve notice to the other party to submit to a physical, mental, or blood examination. And a copy of the notice shall be served on the person to be examined, and the notice shall specify 1. The time and place, not less than 20 days after the notice is served, and 2. Any conditions and the scope of the examination. So, the notice of examination. That examination cannot be earlier than 20 days after the notice of examination is served. So you got to give them 20 days notice, and it also has to be served on the person to be examined and his attorney. 3122. If a party or person objects to the disclosure, inspection, or examination, he shall serve a response which shall state with reasonable particularity the reasons for each objection within 20 days of notice of subpoena ducis tecum. So if somebody is served with a subpoena ducis tecum and he objects, he has to serve a response that he objects with his reasonable particularities, and he has to do that within 20 days. 3122. Business records. Business records produced pursuant to a subpoena ducis tecum shall be accompanied by a certificate sworn in the form of an affidavit and subscribed by the custodian or other qualified witness charged with the responsibility of maintaining the records. And that certificate/affidavit shall state 1, that the affiant is the duly authorized custodian and has the authority to make the certification, and 2, to the best of the affiant's knowledge, the records copies are accurate versions of the documents in the subpoena ducis tecum, and 3, to the best of the affiant's knowledge, the records copies represents all the documents in the subpoenas ducis tecum, and 4, that the records or copies were produced by the personnel or staff of the business. So a subpoenas ducis tecum for business records The person supplying those business records has to supply that certificate / affidavit stating those 4 things. And if a party intending to offer a trial or hearing business records, they shall give notice of such intent and specify the place where such records may be inspected at least 30 days before the trial or hearing. If the other side objects to those business records being used, then he makes that objection